Hello students, welcome to Criminology EPG Pathshala, and I am Neeraj Tiwari, Assistant Professor of Law at National University Delhi, and I am here before you to present the module on Criminal Law Amendment Act 2013 and Victims of Crime. This module is part of the paper Victimology and Victim Justice. Now let us begin with the introduction. The Criminal Law Amendment Act 2013 is a fine example where the law is amended in response to the reactions of the society. The protests erupted post-Delhi gang rape incident has led to the promulgation of the Criminal Law Amendment Ordinance 2013, which was superseded by the enactment of Criminal Law Amendment Act 2013. The Amendment Act was brought in the month of March. Coincidentally, during the same period in 2012, the government has introduced a criminal law amendment bill in the Lok Sabha to bring reforms in rape law. The protest against Delhi gang rape has added to the long-standing demand for reform, which has resulted in the setting up of a committee under the chairmanship of former Chief Justice, Justice G.S. Verma, known as G.S. Verma Committee. The mandate of the committee was to review existing laws and suggest amendments to criminal law to effectively deal with instances of offences against women. The committee recommended for creation of new offences, amendment in existing offences, and enhanced procedural safeguards to protect the female victims. The object was to bring in more deterrence so as to prevent criminals from committing such gruesome crimes. At the same time, the aim was also to protect the victims by bringing more safeguards in both substantive and procedural criminal law. In a way, the Criminal Law Amendment Act 2013 was enacted to serve the needs of the female victims. Most of the reforms were related to cases of acid attack and sexual assault. This module will focus only on amendments made in the interest of victims, which either confer more rights or provide safeguards to crime victims. Now let us go through the learning outcomes of this module. The learning outcome of this module is to make the learners understand the object of Criminal Law Amendment Act 2013, to make the learners aware of specific changes brought by the Criminal Law Amendment Act 2013, and to acquaint the learners with the nature of duty imposed on public servants by the Criminal Law Amendment Act 2013. Let us just go through the position of victims prior to Criminal Law Amendment Act 2013. In the aftermath of UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power 1985, the crime victims have started gaining attention of both judiciary and lawmakers in India. The legislature has introduced many victim-centric provisions in the substantive and procedural criminal laws, whereas the judiciary is consistently attempting to enforce that victims of crime should be recognized as a prime stakeholder in the criminal justice system. The set of amendments brought before Criminal Law Amendment Act 2013 have dealt with issues of crime victims in general and with those of women and child victims specifically. Now the Criminal Law Amendment Act 2013 and victims of crime. As mentioned above, the primary focus of Criminal Law Amendment Act 2013 was to address concerns of public at large towards the increasing incidents against women. The entire efforts of Justice Verma Committee was to bring reforms in existing framework of law. The committee has proposed many changes, but not all were incorporated in the Criminal Law Amendment Act 2013. The changes which are introduced by the Criminal Law Amendment Act 2013 and relevant to crime victims can be discussed under the following heads. Pre-trial stage, reporting of crime. Under-reporting of crime is a serious challenge in our country. Sometimes victim may choose not to report the incident to police, whereas in other cases where victim prefers to report the crime, the police may choose not to register the same. These dark figures never come to light, and the National Crime Record Bureau statistics only show understated crime rates. It also reflects an imbalance between prevalence of crime and its reporting in any region. Therefore, it was necessary to provide a trustworthy system which may encourage victims to come forward and report the crime. The Criminal Law Amendment Act 2013 has introduced two significant changes in this regard. First, a proviso to section 154 of the Code of Criminal Procedure 1973 was added, which required recording of information given by the victim disclosing either commission or attempt to commit offence in the nature of acid attack or sexual assault, preferably by a woman police officer, and in case no woman police officer is available, then by any woman officer. The second proviso to section 154 has attempted to facilitate victims who are permanently or temporarily mentally or physically disabled in matters of reporting of crime. Therefore, where a crime of acid attack or sexual assault is attempted or committed against a woman who is temporarily or permanently mentally or physically disabled, the information regarding such crime shall be recorded by a police officer first at her residence or at a place of her choice. Such information shall be recorded in the presence of an interpreter or a special educator. The recording of such information shall be videographed. Secondly, a corresponding amendment was made in the Indian Penal Code, whereby section 166A was added. Section 166A subclause C obliges every police officer to immediately register first information report in cases where the information discloses commission of a cognizable offence in the nature of acid attack or sexual assault. Non-recording or refusal to record such information shall attract criminal sanction, and the police officer shall be liable for punishment under section 166A IPC. The subsequent decision in Lalita Kumari versus Government of UP has also confirmed that police has no discretion but to register FIR if the information discloses commission of a cognizable offence. Both the Criminal Law Amendment Act 2013 and the decision in Lalita Kumari have attempted to streamline the process of crime reporting by making the process victim friendly and police more accountable. Now, secondly, at this pre-trial stage is the recording of statement. Following the observations of the Supreme Court in Nandani Satpathy versus P.L. Dani 1978 Supreme Court, section 160 of the code was already amended to the effect that no woman shall be required to attend at any place other than the place where she resides. The Criminal Law Amendment Act has effected further changes in the process of requiring attendance and expanded such protection even to a person who is mentally or physically disabled. As far as recording of statement is concerned, subclause 3 to section 161 was inserted, which requires recording of a statement of a woman victim of acid attack or sexual assault by a woman police officer or by any woman officer. Similarly, subsection 5A was added to section 164, which provided for recording of statement of a victim of an offence of acid attack or sexual assault by a judicial magistrate soon after the commission of such crime is brought to the notice of the police officer. The duty of the police officer to get such statement recorded by the judicial magistrate is provided under subclause 3 of the proviso to section 154 of the code. The magistrate shall take assistance of interpreter or special educator if the victim making statement is temporarily or permanently mentally or physically disabled. In such cases, the recording of a statement must be videographed. The Criminal Law Amendment Act 2013 has facilitated the disabled persons even in case of identification of arrested person. Proviso to section 54A provides that where the person identifying the arrested person is mentally or physically disabled, such process of identification shall take place under the supervision of a judicial magistrate. The judicial magistrate shall take appropriate measures to ensure that the methods of identification are designed keeping in view the needs of such person, and in all such cases process of identification shall be videographed. Now let us discuss the amendments brought at the or during the trial. So first, examination of witness or victims. The Criminal Law Amendment Act 2013 has extended protection to victims of sexual assault at the trial stage by bringing significant changes in the code. One such amendment is made in section 273 in matters of recording of statements of rape victims. Way back in 2004, in the case of Sakshi versus Union of India, the Supreme Court has observed that the victims of rape should be provided with comfortable atmosphere to make them depose the entire incident with ease. They should not feel fear or embarrassed. In this regard, the court has issued following directions for the protection of victims of child sexual abuse. First, a screen or shield kind of arrangement may be made to avoid face-to-face contact between the victim witnesses and the accused. Second, in cross-examination, questions which directly link to the incident must be given in writing to the presiding officer, who may put them to the victim or witnesses in a language clear and non-embarrassing in nature. Third, victims of child sexual abuse, while giving testimony in court, should be allowed sufficient breaks as and when required. These directions were in addition to the directions issued by the Supreme Court in the case of State of Punjab versus Gurmeet Singh, where the court has given direction to invariably conduct rape trials in camera as per section 327 subclause 2 of the code. The proviso added to section 273 was to give statutory recognition to the directions given in Sakshi case. The proviso cast a duty on presiding officers to take appropriate measures to avoid any confrontation between the accused and the victims of child sexual abuse who are below the age of 18 years. As provided in the Sakshi case, such face-off may be avoided by using a screen or shield, which will also ensure that the accused can effectively exercise his right to cross-examination. Now, second important amendment is brought in dignified treatment to victims and witnesses. The rape law has undergone many changes post Mathura case known as Tukaram versus State of Maharashtra 1979 Supreme Court. The Criminal Law Amendment Act of 1983 has added section 114 capital A to the Indian Evidence Act, which has enabled a court to raise a presumption that the victim of rape had not consented and that the offence was committed against her will. The burden of proving consent was imposed upon the accused. The amendment was an outcome of the open letter written by 4 professors to the then Chief Justice of India criticizing the judgment in Mathura case on the issue of consent. It took another 20 years to repeal equally degrading and discriminatory provisions on admission of past sexual history of the rape victims, that is section 154 subclause 4 of the Act, which had provided that when a man is prosecuted for rape or an attempt to rape or attempt to ravish, it may be shown that the prosecutrix was of generally immoral character. Sadly, even after deletion of this clause, there have been instances where past sexual history of the victim has been considered and gone against the victim. The Criminal Law Amendment Act 2013 has further strengthened the position by adding section 53A in the Act and clarified that the evidence of character and past sexual history of the victim shall not be relevant in a rape trial to decide the question of consent. Now, let us see the speedy trial. To afford a speedy trial in rape cases, the Criminal Law Amendment Act 2013 has brought change in section 309 of the code. Section 309 provides that where an inquiry or trial is related to rape cases, the same must be completed within a period of 2 months. Earlier, this period of 2 months was to be counted from the date of commencement of the examination of witnesses, but after the 2013 amendment, the period of 2 months to be counted from the date of filing of the charge sheet. And fourth limb of amendment during trial is related to compensation. Now, section 357A requires every state to prepare victim compensation scheme for the award of compensation to crime victims. Many states have prepared victim compensation scheme to fulfill the requirement under section 357A, which contain amount of compensation depending upon nature of offense. It has been noticed that there is disparity in amount of compensation for similar crimes among victim compensation scheme prepared by different states. Therefore, the central government has established a central victim compensation fund to support and supplement the state victim compensation scheme and to reduce the disparity in quantum of compensation. The Central Victim Compensation Fund has fixed minimum amount of rupees 3 lakhs as compensation for the offense of rape and acid attack, whereas for other types of sexual assault excluding rape, the quantum of compensation is fixed as 50,000 rupees. Where the victim of sexual assault is less than 15 years of age, the compensation amount shall be increased by 50%. Even before the Central Victim Compensation Fund guidelines came, the Supreme Court in the case of Lakshmi versus Union of India, known as Lakshmi 1, 2014, attempted to remove the disparity in quantum of amount of compensation fixed for acid attack offences. The court has noticed that the amount of compensation provided for the acid attack in different victim compensation schemes is neither uniform nor adequate, keeping that the acid attack victim has to undergo a series of surgery and corrective treatment. The quantum of compensation must be enhanced to minimum 3 lakh rupees as the aftercare and rehabilitation cost. The court further directed that a sum of rupees 1 lakh shall be paid to the acid attack victim within 15 days of occurrence of such crime to facilitate immediate medical attention and expenses in this regard. The balance sum of rupees 2 lakh shall be paid as expeditiously as may be possible and positively within 2 months thereafter. The court has clarified that it has set the minimum amount for compensation and the state at its discretion may award more compensation to the victim of acid attack. This view was confirmed by the latter bench in the case of Parivartan Kendra versus Union of India, a 2015 decision of Supreme Court. The Criminal Law Amendment Act 2013 has added section 357B to clarify that the compensation to be awarded by the state under victim compensation scheme shall be in addition to the payment of fine to the victim under section 326A and 376D of the IPC. Treatment of victims. Another notable change brought by the Criminal Law Amendment Act 2013 is the form of extending health services to victims of acid attack and sexual assault. The newly added section 357C obliges all hospitals, public or private, to provide immediate first aid and medical treatment free of cost to a victim of rape or acid attack. In Lakshmi versus Union of India, Lakshmi 2, 2015 case, the Supreme Court interpreted the meaning of the term first aid and medical treatment as appeared in section 357C of the code. The court was of the opinion that free medical treatment is not limited to physical treatment to the victim of acid attack, but also include availability of medicines, bed and food in the concerned hospital. The court has issued following directions to be followed. The private hospitals should not refuse treatment to victims of acid attack. Secondly, the hospital shall provide full medical treatment to acid attack victims, including medicines, food, bedding, and reconstructive surgeries. The hospital which first treated the acid attack victim should issue a certificate confirming that the individual is a victim of an acid attack. The victim may utilize this certificate for treatment and reconstructive surgeries or to avail any other government scheme that the victim may be entitled. A corresponding amendment was made in the IPC with an aim to provide effective implementation of section 357C of the code. Section 166 capital B of the IPC prescribes punishment for those who refuses to treat a victim falling under section 357C of the code. In the case of Lalita Kumari versus Government of UP, the Supreme Court has highlighted the object of crime reporting. The Supreme Court has stated that crime reporting is the access point for the victims of crime, and where a crime is reported, well, it reduces the chances of manipulation or embellishment in the information. It also gives credibility to the investigation process, and therefore, in all cases where the information discloses the commission of a cognizable offence, the police officer must register the FIR and should not resort to conduct of any kind of preliminary inquiry which is not allowed under the scheme of Code of Criminal Procedure. In this very case, the Supreme Court has carved out certain exceptions where the police officer is allowed to conduct a kind of preliminary inquiry before registration of FIR, but these cases are limited to first, matrimonial disputes, second, corruption cases, third, cases of corporate in nature, four, cases of medical negligence, and lastly, the cases where there is a reasonable delay in the registration of FIR. In all these cases, the police is given power to conduct a preliminary inquiry to establish whether the information is disclosing commission of a cognizable offence or not. But otherwise, in all cases, the police officer is duty bound to register the information in the FIR book. Now, let us just go and see what we have discussed in last 25 or 30 minutes or so about this module on Criminal Law Amendment Act and victims of crime. The module has a very significant value as far as the victims are concerned, as it deals with the latest set of amendments in the Code of Criminal Procedure, Indian Penal Code, and the Evidence Act. Therefore, it is very much required for all of us to once take a brief look what we have discussed in the preceding paras. So, it can be seen from the preceding discussion that the Criminal Law Amendment Act 2013, like its predecessors, has also attempted to widen the reach of law to cover issues of crime victims. On the one hand, the Criminal Law Amendment Act 2013 has redefined offences of rape, created new offences like acid attack, stalking, voyeurism, etc., and imposed enhanced punishment for these crimes. On the other hand, it has expanded the regime of procedural safeguards in the matters of crime reporting, trial, assistance, compensation, etc. The judiciary has also extended its full support in enforcing the rights of crime victims and taken a liberal approach in deciding matters of compensation. Therefore, it can be said that both the legislature and judiciary presently are working together in an environment and creating Therefore, it can be said that presently judiciary and legislature both are going hand in hand and creating an environment which is pro-victim and to provide all sorts of support and assistance to victim. Such amendments were need of the hour. With this, I conclude and thank you for all for watching this module. Thank you.